Then let us move things along. This is the July 23rd meeting of the Municipal Land Use Board of the Borough of River Edge. It is now 7:30. This meeting of the Municipal Land Use Board of the Borough of River Edge is being held remotely and recorded via Zoom due to the Borough Council Chambers unavailability and is in compliance with the provisions of the Open Public Meetings Act and associated regulations. Notice of this remote meeting was published in the Bergen Record, posted on the front doors of Borough Hall, and posted on the borough's website. The notice included the dial-in login information necessary for public participation and access to this meeting remotely. A copy of the agenda for this meeting was made available on the borough's website near the posting of the meeting notice and included the dial-in login information. During the public comment period of this meeting, if you would like to make a public comment, please press the raise hand button on Zoom or dial *9 on your telephone keypad to raise your hand. The board will address you by name or by the last 4 digits of your telephone number. You may mute and unmute yourself by pressing the microphone icon on Zoom or dialing *6 on your telephone keypad. You must state your name and address prior to making a public comment. Ms. Steinle, would you like to call the roll?
Yes, thank you. Mr. Mayor?
Here.
Mr. Caslin is excused. Ms. Boland?
Here.
Mr. Cray?
Here.
Mr. Gibbons is excused tonight. Mr. Kinigo?
Here.
Mr. Pfeffer?
Here.
Councilman Glass?
Here.
Mr. Gautier?
Here.
And Mr. Salvo.
Here.
Also present, we have our board planner, Mr. Behrens.
Okay. First order of business is approval of the minutes from the June 25th meeting, which were distributed earlier this week. Are there any comments, changes, edits, modifications that need to be made to those minutes? There being none, I'll take a motion to accept the minutes as submitted.
So moved.
Okay, do I have a second?
Second.
All in favor?
Aye.
If this was for the last meeting, I have to abstain. I wasn't at the last meeting.
This is for 625, and the only eligible members are Ms. Boland, Mr. Pfeffer, and Mr. Gautier, because everyone else
Thank
was.
you.
All right. Well, let's do that again. Out of the 3 who are eligible.
Aye.
All those in favor?
Aye.
Any opposed? Any opposed, any abstain? Okay,
All right.
minutes are accepted. Now we did not get the July 9th minutes, correct?
Correct.
All right, okay, so we can move on from there. Next order of business is the amendments to the Borough of River Edge ordinance number 25-14, amending and supplementing the Borough Code, specifically the swimming pool and coverage items. I think if we would like to have some discussion of that, I mean, we received the draft earlier this week. I don't know if Ms. Steinle or Mr. Behrens, you want to kind of walk through the document?
So this was the ordinance that the board had prepared a few months ago about changes to some of the swimming pool regulations, and the council first introduced it last month. They sent it to us for our master plan consistency review, and then they're going to do the second reading, I believe, tomorrow. So this is more of a formality. The board prepared this draft, and I don't know if you have any specific questions or if Tom wants to just do a brief summary, we can.
I'll give my 2 cents, be fairly brief. So as stated, this is the document that was prepared by the board and recommended to the council, primarily to clean up and clarify some of the ordinance terms that the board had recommended about a year ago that the council adopted and implemented. And it turned out that once they were put into practice, there was some further clarification warranted. And specifically, this ordinance, ordinance number 25-14, as Marina mentioned, was introduced last month and scheduled potentially to be adopted by the council tomorrow night. Clarifies a few sections specifically pertaining to definitions related to building area and building coverage, terminology around accessory structures as far as how decks, pools, and patios qualify. If you recall, we gave that additional exception for garage height for for detached garages where there's a pitched roof, and also clarifying that swimming pools do not count as impervious coverage. So again, there's maybe 5 or 10 cleanup items as I characterize them. And the task before the board is to, in accordance with the municipal land use law, is to conduct a master plan consistency review, specifically to determine the extent to which these ordinance changes or amendments are consistent or not consistent with the borough's master plan, and then offer any recommendations to the council for consideration. Obviously, because the board prepared this document, we probably don't have much in the way of recommendations. It looks like they introduced the document verbatim from what the board had recommended. So if you just give me a minute to touch on briefly on the master plan aspect. So the original ordinance that was adopted about a year ago came from recommendations from the borough's May 2022 amendment to the reexamination report, which this board adopted. Again, that dates back to 2022. The board followed suit and drafted a ordinance amendments, which the council ultimately adopted. So I would offer that the amendments are very consistent with that document itself, but because it's a reexamination report, technically not the master plan. I also took a look at the 1984 master plan, which has several goals and policies related to residential development. I would offer that most of these definitions and terms and policies relate specifically to residential development. I think that was the intent to, again, clarify what people could do with their properties, and also to grant some relief and flexibility, given the nature of applications the board was getting. So without further ado, a couple of those specific master plan policies from the 1984 master plan include to maintain the character and viability of all established residential neighborhoods, to prevent the development of incompatible land uses. I would say, I'm just skimming through here, encourage rehabilitation of substandard and deteriorated housing, and then finally enforce building codes, housing codes, and other regulations designed to guide and upgrade structural conditions. So I believe this ordinance has the effect of allowing people to update and modernize their homes in accordance with current, we'll call them taste, or, really things that people come to expect to have in River Edge these days to some extent. So I think from that sense, it makes good sense. The board has discussed these issues at length. And so I can conclude that at a minimum, these provisions are not inconsistent with the master plan. However, the board can find whether there's any inconsistencies, take a neutral stance, or even find that the ordinance amendments are consistent with the master plan. That's all I have.
Thank you, Mr. Barrett. I guess we will kind of walk through the board, see if there are any questions, comments on the amendment, and whether we send it through again with that determination that it is consistent or not. Mayor, do you have any questions, comments on this?
I don't, other than I support it.
Okay, Ms. Boland?
I do have a question, and I'm sorry if it's going back at something that was already discussed, but is a detached garage an accessory structure?
I believe it would be. If
So,
you have reason
the reason I'm worried about it, it says it shall not exceed 150 square feet.
There, I believe, and I'm looking it up right now, I believe there's a separate exception for
Yeah.
garages.
Oh,
because
okay.
We had discussed this, and I want to get you the exact provision. Okay, so yes, I'm looking at 416 dash, and I know you don't have the benefit of the full
I don't
ordinance.
have it right, okay.
Right, so section 416-27 C3A has an
Okay.
exception which
Okay.
allows up to 450 square feet for 2-car garage. So that standard exception for garages remains in place.
Okay, that was it. That's the only thing that stood out.
I
but
can
thank you.
understand how that wasn't clear, so thank you.
Mhm.
Thank you. Mr. Kenigo.
Yeah, just on section 5B, I think the first, maybe it's just me that it's just not making sense to me, but I think the first sentence might be missing a word. Swimming pools, hot tubs, and other bodies of water shall not encroach on any front or side yard required by this chapter. I'm not sure what that means.
It should say setback, I think.
Setback.
Setback, right? It's missing the word
Well,
setback.
well, not necessarily. They're two different things. So the setback is the line at which you can build essentially. The required yard is the distance. Let's use a front yard, required front yard. That's the distance between the front lot line and the setback is the required front yard where you cannot encroach. So there is a distinction. I understand that it doesn't make, normal grammatical sense, but I think in land use parlance, it seems to apply. I'll ask others to chime in.
Is there
Certainly,
a way that we can just phrase it so it makes sense? Because it doesn't, I don't understand it when I read this, and I'm just wondering if just a homeowner comes in here and tries to figure this out.
I think we can clarify it without it being a substantive change. And so
Yeah.
shall not encroach on any required front or side yard area. Well, I get your point. So I think perhaps Marina and I need to put our thinking caps on.
Yeah, because when you say
Yeah.
required by this chapter, now you're referring the reader of this particular sentence to this chapter, but it's not really making sense as to what it is that we're talking about, other than this particular section B.
You might say required by the zone. Maybe that's more clear. Meaning, so I give you the case of a single family property in the R1 zone. So this would mean that a swimming pool or body of water cannot encroach within that required 30-foot front yard area, because we have a 30-foot front yard setback. So the required area is that space within the 30 feet.
How would a swimming pool encroach within a 30-foot?
Well, that's sort of the point, is that you cannot locate it in that area. So like give the context of a corner lot, for instance. You're saying the point is you can't, here maybe another way to put it, you can't impede beyond the required setback. But that's the language. I would say that language is somewhat common in zoning ordinances, but if it's not clear, we should clarify it. And I don't think what you're bringing up is a substantive change. It's just a matter of
Yeah,
clarification.
no, it's a clarification. And look, I mean, if everybody else understands it, then it's just not sinking into my head. So
I get how.
let everybody else chime in.
No, I mean, I fully appreciate how the homeowner will look at this and go, well, what the heck does that mean?
Yeah.
And then call up the building department and say, what does this mean? So I fully appreciate that. So if there's a way, Marina, we could better articulate that, which must go to the council, so they can adopt it properly
Yeah.
tomorrow.
Isn't it just that it's not allowed in the front or the side at all?
Yeah,
So can you just stop at yard? Not say as required by this chapter?
So,
In any
so
front or
here,
side
there
yard.
there is a distinction, and I don't, not to get super, so you could still be in the front yard at the setback line. So there's the required yard, in the case of, let's say, the front yard setback requirement in the single family zone is 30 feet. The 30 feet is the required yard area. Let's say you're at 31 feet. You're still in the front yard, but it's not the required area anymore.
I'm surprised we would allow it even there, like
In
a
the
pool.
front yard at all.
At
So
all.
maybe that's a clarification.
so maybe shall not encroach into any front or side yard. Not encroach beyond any front or side yard setback, or
But do you
Well,
want it in?
I think the point Ms. Boland's saying, there are cases where it could still be in the front yard and comply with the setback, which you would not typically.
Is there a property in town that would even be possible, though?
You'd have to think of a property with a deep front yard. Off the top of my head, I'm not coming up with many. Again, corner lots would be the typical situation that I would think of.
And it
Why-
could be
why can't-
a property where the house gets knocked down and it's now the construction is being placed wherever the person wants.
Why can't we just, I don't know if this really solves it, but can we say maybe just in one sentence, something like notwithstanding anything herein to the contrary, there shall be no pool constructed that enters upon the front yard or side yard of any property, something like that.
I
So
think
it's
if we make too many
Changes. it
wording
becomes
changes, it's
substantive.
beyond like a minor revision, clarification, and it's a substantive change. This is the text that is that's been in the ordinance.
Right. Well, we didn't change this. And so I think again, what it reads or what it's intended to say, and it's been there for a while, is that you can't encroach into the front yard or beyond the front or side yard setbacks. That's basically what it says. To Mrs. Boland's point, well, you could still be in the front yard and within the setback, but it's still in the front yard. And maybe that doesn't matter. Maybe there are a few instances where that actually could occur. Again, I think a corner lot is probably where that would be the most likely place to occur.
Could I just ask, so,
Mhm.
I don't mean to be flip, but I
I'm
mean,
just clarifying what it says.
no, Tom, I'm sorry.
Yeah.
I just want to ask the board, what are we trying to prevent? You know, if someone has a big front yard and part of their pool is in it because they have a big front yard, like, are we saying that's unacceptable to us? I just want to understand what we're trying to do here.
Yeah, if I could chime in on this. Tom, if you would, if a house is on the corner, does it have two front yards?
Yes.
Okay. So that's one area to consider. So corner houses have two front yards. Second is residents really don't want to see someone's pool. So we want to make sure that the ordinance doesn't permit to be in the front yard, but then we have the unusual cases, well, not unusual cases, but the exceptions where you have two front yards because you're a corner lot. And I don't know how to solve that. I'm just throwing that out.
You might consider that if it's been in place for as long as it has, and there haven't been issues, not to say there can't be any future issues, but I think if we tweak it too much, it becomes a substantive
Can
change.
we just take those words out, required by this chapter? Doesn't that accomplish exactly what we need to do? It's the required by this chapter that makes no sense in that sentence.
On any front or side yard.
Period.
The distinction so in you may allow it in a side yard area, and I know that's convoluted, but the distinction is again, you could be in a yard area, but the required yard area goes up to the setback line, and the yard itself is all encompassing. It's the area where you can't build and the area where you can build constitutes the full yard. It's the required yard is the area that you can't build that goes up to the setback line.
Look, I think we can probably you and Marina can probably figure out a way to rephrase it that doesn't alter what you're trying to do here, doesn't take it out of the council's hands tomorrow, and fixes this problem, because I think it's confusing, and I don't think we need to have something confusing. We see that there's an issue and we have to address it.
Okay. I understand the point. I think again, without changing the policy or intent, we would make it more clear.
Yeah, that's all.
Maybe Tom and Marina adding a clarifying sentence instead of revising the current sentence may be the simplest way to avoid having a substantive change and therefore returning us to, reintroducing it.
Right. We understand the goal is to get this adopted.
So
Who's going to challenge it? Like just from a practical standpoint, like if we do change a little too much, who's going to challenge it?
I mean, but the relative likelihood is very low, I would say, but it's not zero.
But it could be someone who wants to put a swimming pool in the front yard, and then they say your ordinance is invalidated and I can put the swimming pool in the front yard.
Plus, our borough attorney will has to make a judgment of whether it's substantive or not. And I think if it's substantive, he's going to say that, and we're going to be back at
Right.
the beginning. We
And
want to get it
Yeah,
right.
I
We
mean-
don't want to rush it, but at the same time, we want to be timely.
Right. Well,
Yeah,
I mean,
and-
to be substantive, I mean, our intent, the intent is we don't want pools in front side yards. So whatever language we want to use to change to, I mean, it's not a substantive change in the impact, it may be wording. But I mean, we're effectively, I don't think anybody's arguing
Right,
that. we should-
because that's the spirit of the current law, correct?
Right, exactly.
Yes, and I'll just add, I'm looking through the definition section of the zoning ordinance, and the definition, let's just look at front yard. It says an open unoccupied space extending the full width of the lot between a principal building and the front lot line. It goes on, but that would be the portion from the front lot line to the principal building. That's everyone's understanding of what the front yard is. And that's the same, that goes the same for the side yard. An open unoccupied space between the sideline of the lot and the nearest line of the principal building. So based on
Same.
how we have it worded now, you can't put a swimming pool in the front yard or the side yard regardless of the setback.
Mhm.
Because the definition of front yard is the front lot line to the principal dwelling. The definition of side yard is side lot line to principal dwelling, or if it's a corner lot, it would be that other front yard.
That
And
makes
that-
sense. Pools in
that
the
makes
rear yard.
sense.
So where there's no building, is it still a front yard?
Interesting question.
Yeah, so
Yeah.
the issue could be on a corner lot where the front yard is technically a side yard, but the space behind the principal building, but it is, I guess then it would be, then it would
It'd
be
be a use,
either a
it'd be a
rear
use
yard
issue at that
or a
point.
side yard, yeah.
Yeah. If you had an undeveloped lot, let's say it didn't have a house on it and you wanted to put a pool or amenities, it would be either the
Yeah.
lots would be merged but through case law because they're undersized, or there'd be a use issue from not having a permitted, you can't just have a pool that's accessory to a principal structure on another lot, for instance. I know getting super technical, but
And we have a
Yeah.
few properties also in town that have like 3 frontages, right? I remember there was a pool a couple
Yeah.
of years ago that there
Yeah.
was 3 front yards, and
yeah,
they didn't really have a backyard. They just had like 3 front and a side or something. So
there's a
this would
few.
affect
Yeah.
them. Yeah.
yeah, Mr. Chairman,
Yes.
I would just say one last thing on my part. I agree with the mayor that this probably can be resolved just by adding a clarifying sentence. And with the concern in mind that this not be viewed as a substantive change, I would just suggest, you can write it however you want to write it. I would just suggest that we start the sentence with something like "for clarification purposes only." And then you follow that with whatever clarifying language you want to have, so that it's clear that this new sentence is not changing anything substantively, but just clarifying what our intention is, what the intention of the ordinance is. So that's my suggestion. I don't think we could write it by committee, but that would be a suggestion.
Thank you, Mr. Pfeffer. Mr. Gautier, any thoughts?
No questions at this time. Thank you.
Okay, Mr. Salva?
No questions, thank you.
Okay, so it sounds like where we are is at the point where we all agree that the amendment does meet with our understanding and is consistent with the master plan, but we have the one item that needs some clarification. Are
Mr.
we
Chairman,
agree-
if you don't mind, you didn't.
Oh, I'm
inquire-
sorry, I'm sorry.
It's okay.
Last-
I know there's a lot of moving parts here. I just wanted to mention briefly that I wasn't able to deep dive into this like I sometimes do and read every word, which I like to try to do. So, let me vote. but in concept, I agree with everything. Thank you.
Okay, thank you, Mr. Councilman Glass. So are we in agreement that we would be comfortable with having Mr. Behrens and Ms. Steinle maybe write, either modify that particular sentence or add some language that would clarify our intent there? And with that being the case, are we comfortable with returning this to the council as being determined to be consistent with the master plan?
I am.
Is there anyone who would like to take a different approach or is not comfortable with that? Okay. That being the case, do we have a motion to accept this amendment as discussed with the further modification to be provided by Ms. Steinle and Mr. Behrens?
Moved.
Second,
Thank you, Mr. Kenigo. Second was, I missed.
And
Second.
Mr. Pfeffer.
Mr. Pfeffer. Thank you, Mr. Pfeffer. Stanley, you want to call the roll?
Yes, thank you. Mr. Mayor,
Yes.
Ms. Boland,
Yes.
Mr. Cray,
Yes.
Mr. Kenigo,
Yes.
Mr. Pfeffer,
yes.
Councilman Glass,
Mhm.
I think we lost him briefly.
Mhm.
Mr. Gautier,
Yes.
Mr. Salva,
Yes.
and Councilman Glass, are your vote?
I'm going to abstain. Thank you.
Abstain. Okay, the motion passes. And Tom and I will come up with a clarifying sentence to add to that and send it to the council tomorrow, or to the clerk tomorrow for the council's review. And just as a point of clarification, normally I have Mr. Gibbons sign the certification, but since he is absent tonight, if we could just appoint an acting secretary to sign these, maybe Mr. Pfeffer or Ms. Boland, because they were at the meetings that apply.
Fine with me. Unless Ms. Boland wants the honor.
No, that's okay because I have a meeting tomorrow night. I think it has to be signed tomorrow.
Yeah,
Okay.
I'll be around,
okay,
you know, during the day.
thank you.
Thank you all. Now, moving on to the memorializations. We have the 124 Jefferson Avenue, Block 613, Lot 13, proposed detached garage for David Allen. I believe the documents were sent out to everyone on the board. Is there any modifications, changes, etc., or are they accepted as submitted? Being that there's no objection, can I get a motion to accept the amendments as provided and have them memorialized?
So moved.
All in favor? Thank you. Mr. Gautier, do I have a second?
I'll second it.
Okay, thank you, Mr.
Mr.
Pfeffer.
Pfeffer. And I'll only call those eligible. There were some absences. Ms. Boland,
Yes.
Mr. Pfeffer,
Yeah.
and Mr. Gautier.
Yes.
Okay, the motion passes.
Yes. And second memorialization is for Daniel and Danielle Rappaport, 726 Center Avenue, Block 411, Lot 9. A proposed addition, alteration, renovation. Again, this has been shared with the members of the board. Any comments, any modifications that anyone deems necessary? Okay, if they're accepted as is, gonna have a motion to approve.
So moved.
Thank you, Mr. Gautier. A second?
Second.
Second.
You, Mr. Was that Mr. Canigo?
It was, yep.
Okay, thank you. Ms. Steinle?
Well, Mr. Canigo was absent at that meeting, I
Oh.
believe, on the 25th.
Oh, okay,
Okay, second.
So, Ms. Boland. I'll just call those eligible. Ms. Boland,
Yes.
Mr. Pfeffer,
Yes.
and Mr. Gautier.
Yes.
Okay, the motion passes.
and that is everything on the agenda. Are there any issues, items that any of the board members would like to bring to the attention of the rest of the board? It's 8:01. Congratulations. We did this
Just a
quick.
note,
Oh.
our next meeting is August 13th. We have a residential application scheduled that night. So if you can make it, please do. I will have the envelopes with all the documentation at the police department by Monday.
All right.
Mr. Alter, that's the one I let you know.
Yes.
I'll have to recuse myself, right? Okay.
Right, that's on Park Avenue.
Yes.
Yep.
Right across the street from me, so I can't comment on that one. Okay, that being the case, do I have a motion to close the meeting?
So moved.
Okay, second,
Second.
all in favor?
Aye.
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 I'm assuming nobody's going to oppose or abstain, so. Thank you all.
Thank you all.
Good night, everyone.
Have a good night,
Bye.
everyone.
All right, thank you.
Good
Good night.